In every real estate deal, three words come up: title, deed, and escrow. When you buy a home, which one proves ownership? The title or the deed? Here's the difference that every buyer and seller should know. Hi everyone! 안녕하세요. 你好. I'm Lauren Chenfu, your Las Vegas lifestyle specialist. Most homebuyers and sellers think a deed and a title mean the same thing, but they don't. I get this question a lot from my clients, and understanding the difference can save you a lot of confusion or even protect your investment during closing. Today, we're breaking down what title and deed really mean and why both matter so much when you're buying or selling a home. Let's start with title. Title is not a document, it's a concept. It's the legal way of saying you have ownership rights to a property. Think of title as a bundle of sticks. Each stick represents a different right: the right of possession, control, enjoyment, exclusion, and disposition. When you have all those sticks, you have complete ownership, what we call fee simple absolute. Here's a simple analogy. When your mom bought your lunchbox for school, she had a receipt. That's like the deed. When she wrote your name on the box, that represented title or ownership of that lunchbox. Before any property can be sold, a title search is performed. This is when an attorney or title company goes back through public records, checking deeds, liens, court cases, bankruptcies, and more, to confirm who truly owns the property. The goal is to make sure there are no surprises, like unpaid contractor liens or old ownership claims. Then, there's title insurance, your safety net. It protects you in case something was missed during the title search, like a forged deed or a recording error. It either defends you in court or compensates you for any losses due to title defect. You can transfer ownership until the title is clear, meaning no liens, no unpaid taxes, and no judgments. Once those are cleared, your title is marketable, ready to be transferred legally to the next owner. Now let's talk about deeds, the physical, written documents that prove ownership. A deed transfers title from the grantor, that's the seller, to the grantee, the buyer. It includes the property's full legal description, both parties' names, and must be signed, often in front of a notary. According to the statute of frauds, a deed must be in writing to be valid. Once it's signed and delivered, ownership has legally changed hands, even if it hasn't been recorded yet. Recording the deed in the county records simply gives public notice that the transfer has happened. There are several types of deeds, and each offers a different level of protection. General warranty deed, the most common in traditional home sales. It guarantees a clear title throughout the property's history. Special warranty deed covers only the time the seller owned the property, often used in commercial deals. Grant deed confirms ownership but doesn't promise future defense against claims. Quitclaim deed transfers whatever interest the grantor has with no guarantees, often used between family members. Bargain and sale deed, common in foreclosures or tax sales, comes with no warranties, and buyers assume any existing liens. So here's the key takeaway. Title is the concept of ownership, your legal rights to the property. Deed is the paper that transfers those rights from one person to another. When you fully own your home, you hold both the title and the deed. Understanding this difference helps you protect your property rights and sound like a pro at your next closing. Before we wrap up, let's talk about one more term that ties everything together: escrow. When you're buying or selling a home, escrow is basically a secure middle step that protects everyone involved. It's where your earnest money and the property documents are safely held until every part of the deal is ready to close. The escrow officer makes sure the title is clear, the deed is prepared, the buyer's loan is ready, and all the paperwork lines up. Once everything checks out, the deed is recorded and the seller gets paid. The home officially transfers hands. So, think of escrow as your transaction safety zone, making sure the process stays fair and secure from start to finish. The purpose of escrow is to protect both parties until all conditions of the purchase agreement are fulfilled. The buyer deposits earnest money into the escrow account to show good faith. The seller places the property's deed and disclosure documents into escrow. Essentially, escrow acts like the referee of the real estate transaction, making sure no one breaks the rules before the deal is finalized. If you're enjoying this breakdown, don't forget to watch my other video on new construction tips in Vegas, the link in the description. It'll save you headaches before you even start. So, to wrap it up, your title is your legal ownership of the property, and your deed is the physical document that proves that ownership and transfers it when you buy or sell. Understanding the difference helps you avoid surprises during closing and gives you more confidence as a homeowner or seller. If you found this helpful, don't forget to like, subscribe, and share this video with someone who's buying or selling a home. And if you're here in Las Vegas and thinking about your next move, I'd love to help guide you through the process. This is Lauren Chenfu, your Las Vegas lifestyle specialist. See you in the next one.